Are we good to get started, or give it a couple minutes for people to trickle in?
I was told that it should just start letting people in. Yep. It looks like there are people rolling in. So we will give it a couple, maybe give it a couple minutes.
Sounds good. Give it till 11:02. I think we are probably at a critical mass. We may have some people trickle in as we go, but we've got all kinds of intellectual property law fun to go through today. So um, let's go ahead and dive in if that's all right with the team at IDW. And thank you to Indie Design Week for having us here today. My name is Garrett Hutchinson. I'm an associate at Taft. My colleague Rhea Govindadas is speaking with me today, and we are here to talk to you about kind of a boot camp on intellectual property, some of the basics and the pitfalls that we see come up over and over again in our practice, and how you can avoid some of those pitfalls so that you're not calling us in a less than favorable situation and can call us with happy projects. All right, let's go on to the next slide. A little bit about our firm. Taft has been around for about 140 years, and we recently actually expanded to have 14 offices now. When I started here a couple of years ago, I think that was 11, so we're growing fast. We are a Midwestern firm technically, but we expanded out to Colorado, Michigan, moving out Arizona. We also have offices in Indiana, Kentucky, Ohio, all across the country. We have attorneys that practice in just about any practice area you can think of, so we are able to assist with issues ranging from environmental law to business restructuring, all the way to the intellectual property type issues that we were talking about today. We've consistently been ranked, including our IP practice, has consistently been ranked by a number of industry publications and other accolades that have recognized that Taft is bringing an excellent level of client service across the board. And we do have a pretty big focus in this kind of law and these intellectual property issues that we're talking about today. We actually have over 100 IP attorneys throughout the United States that can assist with everything from patents to trade secret litigation to protecting your right of publicity and everything in between. And there's just a few more of those nice accolades I mentioned. So to start off, before we can really get into intellectual property, I think it's helpful to talk a little bit about what is property and on a really high level. And I think that's useful because it's something that I had never asked myself really until I got to law school. And then I realized that I didn't have a good answer for it. But I really liked the answer that my professor put out, which is that a property right is a right that other people will enforce for you. Usually that's going to be the government that enforces it for you. But it's that enforcement by others that takes it from saying, "Hey, I own this is mine," to actually having a property right in it. And there are three main kinds of property. There's real property, not as opposed to fake property, but as in real estate. And real property is land, your home, the area that your business is on. It is property rights and land. There's personal property, which is probably the other kind of property that you think about when you hear the word property, and that's your stuff, your office equipment, your computers, your PS5, anything like that that you own that's a tangible item. And then the third kind of property that we're talking about today is the one that's a little more wiggly, intellectual property. And that's a pretty broad umbrella, and it sounds pretty abstract. So what is intellectual property? That is what we're here to talk about today, and it comes in a few forms. An intellectual property right, though, at its core is a right in something intangible that others will enforce for you, and that can be either an invention or a process, which would be protected by a patent. It could be a unique and original expression of an idea, which would be protected by a copyright. It could be the secret sauce that you have kept others from knowing that makes your brand great, which would be a trade secret, or it could be just the embodiment of the goodwill that you have with consumers, your brand itself, McDonald's, Apple's, and that would be a trademark. And with that, I will kick it over to Rhea to talk about what is a trademark, the first of those exciting areas.
So we're just going to dive right into what a trademark is. So technically, it's a mark to identify the source or origin of goods and services that distinguishes it from other goods. To put that more plainly, it's what consumers think of when they see a word and associate it with your brand. So that's anything that they can use to identify you. So that can be colors, that can be sounds, scents, packaging, products, store layouts. A lot of fast food restaurants from the 90s, you think of like Taco Bell interiors or McDonald's interiors, those kinds of things. And then kind of moving into some examples, we have like the John Deere tractor. So you think of that distinctive green and yellow contrast on the tractors, or the shape of a Chanel bottle. Even if Chanel wasn't written on the bottle, you'd be able to identify that's a Chanel perfume, or like that's a John Deere tractor. The same can be said about a Coke bottle. That shape is very distinctive. It's recognizable to consumers. When you see it, you think Coca-Cola. Or when you see the In-N-Out sign, you think In-N-Out. Even if the word wasn't on it, you would recognize it as the brand. So that's really ultimately what the trademark is. It's what the consumer sees and then associates with you. So trademark rights arise from use in commerce. So that's putting it on your goods, putting it on your services. You don't need a registration to have trademark rights. You inherently have trademark rights when you use a mark in association with your brand. But where registration comes in is that it strengthens that protection that you have inherently, and it gives you a right in court if somebody uses your brand or your packaging or your color scheme in a way that is infringing on your use. It gives you a right in court to go after that person and claim your rights without having to prove in any way that you've been using this trademark for a certain amount of time. So we recommend registration for your trademarks always, because it's an investment in you, it's an investment in your brand, and it's a way to just make sure that all the efforts that you've put in to your business are recognized and enforceable and able to protect you as much as possible. So some benefits of registration are that you have exclusive nationwide rights for the goods and services. There's a legal presumption of ownership. So like I said, if someone infringes on your use in court, you can come back and say, I have a valid trademark. And it gives you the right to use the registration symbol, which is that R with a circle around it. And that helps other people recognize that your mark is a trademark that has registration rights, and helps deter other people from using that trademark. So trademarks are, like we said, a brand source identifier. So in order to be a trademark, it should be inherently distinctive. And we're going to go into what distinctiveness means further into the presentation. But on its basis, it's basically just something that you can recognize as being part of your brand. So a lot of times we differentiate it from words that are descriptive. So that would be if I said like a pen holder, like you know what that means, you know what that is. You don't associate that with any specific brand or any specific individual. There's no quality associations with that. It's just words that are used to describe an object. Where like your trademark would be a word that immediately invokes that association. And that's different from pre-existing brands and their trademarks that already are in existence. So when we file trademarks for our clients, which is businesses that are looking to establish a brand or protect their brand, we look at the trademark register, which is a database that the federal government keeps of all registered trademarks. And based on that register, we can kind of see whether your trademark is different enough from those brands or if it's too similar and it could cause problems with infringing on their rights that they've established through their registration. And strong trademarks are great for your brand. They can help you build goodwill, brand awareness, and trust with consumers and clients that when they see a green and yellow tractor, they know it's John Deere, they know it's going to do good work. Or if they see your brand on a certain product, they'll pick it up in the store because they know that it's going to be a good product. So those are all positive benefits that come with the trademark registration. And the gold standard we use when evaluating trademarks, which is kind of roots back to that difference from pre-existing brands, is likelihood of confusion. So trademarks also act as a form of consumer protection. And because consumers rely on these marks when they're making decisions and associating them with quality or with safety or with whatever reputation you've accumulated as a brand, when we're evaluating your trademark or another trademark besides your mark, we want to ensure that it's not confusing to consumers to have two marks that are similar. So we call that likelihood of confusion. So if there's two marks that are too similar, it may be confusing to consumers. They may mix up quality, and that's bad for your brand or bad for the other brand because it could damage your reputation, harm your reputation, or prevent you from keeping those consumers that you've worked so hard to market to. So to kind of expand upon that distinctiveness identifier that we had talked about earlier, there's kind of a spectrum for how we evaluate how distinctive a mark is. So ideally, the strongest trademarks are going to be arbitrary and fanciful, and marks that are more generic or descriptive have a more difficult time obtaining registration. So a generic mark would be a very weak trademark. It's not distinctive to the consumer, and the USPTO won't grant you protection for it. You can't enforce use of it to other people. So an example of that could be, like I said earlier, like pen holder, or like if you were trying to sell bananas, you can't just call it banana. Or with Q-tips, where that term has become so well known to everyone that it doesn't hold a meaning to a specific brand. That's just what we call that item that people use to clean their ears or whatever you're actually supposed to use Q-tips for. And then kind of moving down the line, we have descriptive marks. So those are things that, while they may be descriptive of a good, so like American Airlines, which is an airline that operates in America, there are arguments that can be made sometimes to obtain a trademark if people associate that descriptive language with a certain brand. So American Airlines, over a span of 50, 60 years, has accumulated a reputation with consumers of being a quality airline, or whatever your association with American Airlines may be, that you know it's a brand identifier. Or Home Depot, which is descriptive of a place you go to buy home items, but over time consumers have come to associate Home Depot with the color orange, with a specific store, with a certain quality of products. So descriptive words are not strong trademarks, but over time and with use, they can become protectable and somewhat acquire distinctiveness with the consumers. Suggestive marks are marks that may be kind of descriptive in the sense like Burger King, where they sell burgers, but it's not descriptive in entirety. So like Kings are not something you normally associate with burgers. So when you see Burger King, you think, well, they sell burgers, but then what is Burger King? And it kind of leads you toward the brand and creates like a distinctiveness in association with something that may otherwise be considered descriptive. And then we move to arbitrary. So those arbitrary and fanciful are both very strongly protected words. They're kind of the sweet spot for trademarks. And those are arbitrary words are real words, but they have no association with your product. So a really great example of that is Apple computers. So an apple is a descriptive term for fruit, but in connection with computers, there's no association that a consumer would immediately think if you didn't know about the brand Apple. So it's a really good arbitrary mark in connection with electronic products. And then moving down the line to fanciful, those are words that are completely made up. And they're very strong because no one else is using them other than you. You made it up. So that would be things like Adidas or pharmaceutical brands. When they launch new drugs, those are often fanciful. They just make up words like Ozempic or Advil, or these words are just made up words that don't mean anything else. And those are really strong distinctive trademarks because nobody else can argue against them and say, well, I have a right to use this mark for something else because it means this. So that's like a very top level overview of what all these things mean. I know that they're all kind of sound really similar at face value. So if you have any questions, just pop them in the Q&A. We'd be happy to clarify. But moving forward, when you do have a trademark or when you're using a trademark, something that's important to keep in mind is that trademarks are not nouns, they're source identifiers, not the product itself. So like we had talked about before with words that are generic and Q-tip, you don't want to be using your trademark interchangeably with the product that you're selling because you don't want you want your consumers to associate your trademark with your brand, not with the product, so that they don't apply your trademark to every product that's similar. So may I have a Kleenex would not be good for is not a proper use of a trademark term, where may I have a Kleenex tissue is the proper use because that differentiates your brand from all tissues. That Kleenex is a specific tissue that's soft, it's durable, it is the one that you want to reach for when you're looking for a tissue, so that people don't just think every tissue is Kleenex tissue. It helps protect your reputation, protect your product, protect your brand. And when you're using these terms, the little TM that you see after your trademark name, you can use that whenever you want. You don't need to have a registration. You don't need to have any type of protection. It really works to your benefit to use the TM as much as possible because it shows that you're intending to use your brand name as a trademark. So when you pursue registration, or if somebody else were to come and you try to use your unregistered trademark, you can point to that TM use and say, we've always intended to use this as a trademark. It's like a huge part of our brand. We've invested in this. We've made the effort to use this TM to identify that. And it's your right to use it whenever you want. The registered symbol is a specific identifier only for federally registered trademarks. It's important not to use that mark until you've been granted an official certificate of registration from the USPTO. And if you use that R with a circle around it before you're granted a registration, it can harm your ability to obtain a registration. It can be perceived as you wrongfully conveying that you have a registration when you don't. So that's really not something that you want to confuse. So when in doubt, use the TM. If you have that registration, you're welcome to use the R whenever you want.
I'll just jump in with a quick aside on the what Rhea was saying about trademarks becoming generic over time. If you ever get a chance, there's a really fun video that Velcro put out that gets showed in law school classrooms a lot, where they actually did a whole music video with a song asking people to stop using Velcro as a generic word for fastener loop or hook and loop fasteners. It's probably only funny to nerds like me, but it's a great video.
And so then just to kind of recap everything we talked about, this is just trademarks in a nutshell. So some things that you can do as a brand when you're discussing your trademarks, talking about your trademarks, is knowing what trademarks protect. So that's names, logos, slogans, and anything that's identifying your products or your services. And then consider professional help. Trademarks are one thing that can seem like a very easy application on the surface, but there's a lot to them. And we always love helping people establish their brand, set their brand forward. And even though trademark registration can be a little expensive on the front end, it saves you a lot of money on the back end when it comes to things like searching for existing uses of other trademarks to prevent conflicting with other brands, or it can save you from a really expensive rebrand further down the line once you put money into marketing and products and packaging. So we just really like helping people from the ground down, like really set the stage to build your business and your products to protect you as much as possible and protect all that effort and work you're putting into marketing. And then searching for your use. So that's something that we do in our job a lot. And that's checking the USPTO databases to do online searches of existing trademarks, just to see what's out there and make sure your name or your logo isn't taken. And a lot of times that isn't as intuitive as it seems. The USPTO will consider things that are similar, even if they're not spelled the same way, if they sound the same, if they mean the same thing, even if they're different words, or if they're foreign translations of the same words. All those things are considered similar. So it's important to really cover your bases of what's out there before you invest time and money into using a trademark. And then establishing your rights. So the rights being the second you use that mark in business, you put it on a product, you're selling it to consumers, you're advertising it to consumers. And the more consistent your use is, the stronger your protection is. Filing for registration, like we talked about, that's the best way to protect your time, your efforts, your money. And registering with the USPTO gives stronger legal rights, it gives nationwide protection, and it gives you the ability to enforce your mark in court. And then make sure you're protecting your trademark once you obtain it or once you use it. Your brand is valuable, your efforts are valuable. So make sure other people aren't using that trademark and riding off that reputation that you've built. Address potential issues early with people who are using similar marks to protect your brand. That's another thing that Garrett and I do is we'll reach out on behalf of businesses we represent to people who are using trademarks that are similar and stopping that use before it impacts our clients' brands. And then using the right symbols. So like we said, use that trademark indicator, that TM, as much as possible. It can only help you, but only use the registered R with the circle once your mark is officially registered with the USPTO. And then a trademark is not an indefinite protection. It does require maintenance. It requires continuous monitoring, continuous filing. So make sure that once you get that trademark, you're keeping your mark, you're using your rights, you're meeting deadlines, you're doing all those things to protect your investment in your brand. And now Garrett's going to talk about copyright.
Thank you, Rhea. So with that, what is a copyright and how is it different from a trademark? I often have questions like, can I copyright my trademark or things like that? And the answer is usually no. Although as we'll see, there's kind of some situations where you sort of can. So what a copyright is it is your right in an original work of authorship that's been fixed in a tangible medium. Easy, right? No, not really. In English, what that means is that it protects any idea that you record, whether that's on the tape or writing it down in some tangible way, in a way that's original to you. The idea of star-crossed lovers is not something that can really be protected, but if Shakespeare had never written Romeo and Juliet and wrote it tomorrow, he could protect that particular expression of that idea that's been recorded. And the duration of the protection that copyright offers, that limited monopoly during, is the life of the author plus 70 years in most cases. In some cases, it can be if the work is found to be authored by a company or other legal entity that's not an individual, that's typically 95 years. So when you create a work, whether you take a picture or paint a painting or record a song, if that work is original and creative, you automatically have a copyright. It's kind of like how Rhea was talking about, when you use your trademark, you develop rights as soon as people start to identify it as your brand. With copyrights, it's as soon as you create it, you actually do have rights in that. The question is what you can do with those rights. So it is still very important to obtain a registration and often to do so quickly in a copyrighted work, even though you already have rights, because most importantly, a registration is required in order to file a federal lawsuit. So copyright is kind of an odd right because you have it as soon as you create the work, but you can't really do anything with it until you register it. It's also provides certain damages, and if you register within a certain amount of time creating the work, that opens up more options for damages and importantly, attorney's fees from the other side if you win. So the timing of calling your lawyer or filing that application as soon as you create a work, or at least before you publish it, can be very key. I mentioned open broader damages options. The other big one is statutory damages. Because copyright damages are often difficult to prove, it's sort of hard to quantify how you were harmed by somebody using a work you created. The law has created this idea of statutory damages that they'll just set an amount that is in the court's discretion, but up to $150,000 per work. And if you have obtained your registration in a timely fashion. So what does copyright not protect? Well, the big one, really everything that copyright doesn't protect, is the public domain. You've probably heard that term. I remember back when I was in school, they had this entire video on the public domain and fair use made up of short little clips of Disney movies. But really the public domain is anything that cannot be covered by copyright. So that's things that could be covered by patent, might not be covered by copyright because they're a process or an idea. One that I've run into a surprising amount of times in my career is recipes, are an example of something that's really difficult to copyright because it's taking a natural process and just writing down what you need to do to make that process happen. The Copyright Office usually finds that there's not originality in something like that. Facts. You may be able to get a copyright in the way you organize facts. So if you have an encyclopedia, you can probably get a copyright in the way you express the ideas in there and the way that you've laid that out. But what you can't get a copyright on is the fact itself. If you're a news source, you can't write the first story and then say that no one else can report on that, the topic that you just wrote about because you wrote it first. Ideas, and that one gets really sticky as to what the line is between copywriting an idea and copywriting an expression, with some things that are what they call thinner of a copyright. At what point is something just trying to prevent anyone else from doing something that's the same idea versus expressing this idea in the way that I did? At what point does this sound too much like my song? And that's where lawyers like Rhea and I can get in and argue all day. The government works, or the US government, most of their works are going to be exempted from copyright. And then kind of very basic things, symbols, titles, colors, things that are kind of, we don't want to give anyone an exclusive right to use it because it would hamper everyone else creating their works. If somebody had a color or a copyright in the color red, that would hurt the art world quite a bit. Fair use is kind of the other big exception to copyright protection, and it is unfortunately not a very straightforward one. Fair use is the idea that there are some uses that even if something is protected by copyright that are just fair, you should be able to do that. Usually there's a list of statutory kind of categories that are usually considered fair uses: news reporting, comedy or comments, criticism, parody, scholarship. But even if something is within those buckets, it's not necessarily a fair use. And even if something is outside of those buckets, it's not necessarily not a fair use. Really, fair use is when you're using something without infringing the copyright because you need to use it for some valid purpose, whether that's to write a review of an album or whether to report on the album coming out. You may need to use the album's name and cover to talk about that, but you're not actually infringing on what the artists themselves are doing. You're not taking money out of their pockets or stealing sales by reporting it. That's just commentary on what they're doing, and so that should be allowed. The Supreme Court recently has kind of thrown the world of fair use into a bit of a tizzy because by substantially changing the test in a case involving the Andy Warhol estate. I bring that up just to say that probably the question that I hear the most in the copyright sphere is, well, isn't this infringement a fair use? And the answer is usually it's a really gray area, and we're probably going to have to go to court to find out. So the takeaway is if you think something that you're doing is probably a fair use, you should ask your legal department before and not after, so that you find out before it's been posted and before somebody that might own that work has found out it's been posted. And that is a good segue into copyright infringement. Copyright infringement, like trademark infringement, is when you step on somebody else's rights, when you use a work that is owned by someone else. That sounds pretty straightforward, but unfortunately, as with many things in life, it gets a little less straightforward as you dig into it, because as you can imagine, you don't necessarily have to have copied a song note for note in order to have infringed that copyright. If you go and perform somebody else's song without a license and just do a straight cover, you've not obtained any rights to do that. The venue you're performing in hasn't obtained any rights. That's probably an infringement. But it might also be an infringement if you write a song that's in the same key with half of the same lyrics, covering similar themes and similar instrumentation. There's a lot of gray area there, which is unfortunate because copyright infringement is a strict liability claim, meaning that regardless of your intent in what you're doing, if it's found to be an infringement, a court will find you liable. So the thing to do is to what we call clear works that you may be posting online and either get a license to it or have an attorney or a firm run searches to ensure that there's not anything that you're stepping on by posting that online or using it. Another thing that you've probably heard come up a lot in the copyright sphere is the Digital Millennium Copyright Act. That is basically a carve out for online service providers and a few other kinds of entities to protect them from liability as long as they comply with certain requirements. That is how Facebook is really, or Twitter is able to exist because they are not liable for the things that people post on their platform unless they fail to comply with the Digital Millennium Copyright Act. And really what that means is that they need to take things down when they get a report of something infringing, and then that starts a process that's prescribed by statute where the person who posted it then can object to it being taken down. That is particularly pertinent for people that are selling on places like Etsy or other similar marketplaces these days, because the companies running them have tended to go for a safer than sorry approach and just take things down as soon as they get a complaint without necessarily looking into it as much. So it can be important to be keeping an eye on whether there's anything that is likely to get an objection if you put it on a marketplace like Etsy or Facebook Marketplace or resellers on Amazon, because that is a good way to, or a thing that often gets taken down. The other thing that's been emerging a lot lately that's worth noting to this audience and the copyright sphere is what's called in our line of work copyright trolls. And these are people that essentially they buy up a lot of copyrights that they never intend to use, they only intend to enforce. And what that looks like usually is buying a large amount of stock photos and then having artificial intelligence kind of troll the internet for any time those photos are posted, and then they send a cease and desist letter once they are, usually asking for $3,000 to $4,000, just in the range where it doesn't really make sense to hire an attorney. I think the lesson with that is emerging with those is to make sure that anything you post on your business's website, social media, anything like that, make sure that you run it down so that you have a license and that you are sure you're not going to get one of those letters. Looks like we have a question in the Q&A. That's a great question. For those that, in case it's not available to the whole group, someone asked, how do you recommend navigating font licenses as a graphic designer? The copyright behind fonts has always been a bit confusing to me, and I've heard some very unfortunate stories from folks who have accidentally violated licenses. How can designers ensure that their usage is legal and protected? That's a great question, because fonts are a really tricky kind of copyright indeed, because it's, I referenced earlier things that are called thin copyrights. It's kind of a narrow scope of protection. That is, a font's a great example of that, because it really, nobody can own the alphabet. They're only owning that very specific way that that's being expressed. To answer that question, I think in particular, the best solution is always going to be consult with your legal team or with an attorney to have them kind of clear a use. If it's a font that you don't have a direct license for, or if it's a new font that you want to make sure it doesn't infringe. Both because that may be able to identify issues, and two, because if they don't identify issues, that you then have a record that you didn't willfully infringe anything, which can reduce your damages later. But really the best practice is to try and use fonts that you already have a license to, unfortunately, or if you create something that to kind of run it down and make sure that you've done everything you can to make sure there's nothing else out there that you may be infringing on. At a certain point, though, it does become a question of risk tolerance, because it is impossible to prove a negative. And that's where that letter from your attorney saying we looked into this and we don't think you're infringing can come in handy later. Hopefully that answers the question, and we'll have our info up at the end of the presentation. So if you'd like to connect offline, I'm happy to do so. On to next slide. So takeaways for copyright: know it's protected. It covers original tangible works such as books, movies, musical recordings, songs, anything written down, art, really anything that you can record in some way that's original. Understand what it doesn't protect. Just because you wrote Romeo and Juliet doesn't mean that you can stop everyone writing star-crossed lover stories in the future. It doesn't cover facts. Just because you reported on this big news story doesn't mean you can stop everyone from reporting on that. They just can't do it in the same way that you did. Register your key works. The things your company produces are assets, and you can't do a lot with those assets unless you can protect them. So make sure that if something's going to be important to your business, you've registered it so that when you find someone else using it and making $1 million off of it, you have recourse and you don't have to wait for an application to go through the Copyright Office. Create original content. That one sounds obvious, but you'd be surprised the things I've heard. Don't copy things. Don't, if you can avoid it, even take elements from other sources unless you've cleared them and gotten a license. Use clear contracts. This is a little beyond the scope of this presentation, but it's worth mentioning that this is the one where anytime you have a contract with a copyright component at all, I would have an attorney look at it, because this is the area that I see even attorneys get wrong the most, is when you have hired someone else to create a work for you. Figuring out who owns it within that contract requires very specific language. And there's a lot of statutory formalities to hit that even IP lawyers that don't specialize in contracts specifically can get mixed up. So make sure that your contracts are good and that you've consulted with an attorney before entering into any agreements. Keep good records, because copyright is an intangible right. It's harder to trace back the chain of title than it is for, say, a plot of land, unless you keep really good records yourself. And so the better your records are, the better you're setting yourself up if you ever need to enforce your copyright or, God forbid, and defend against a claim of infringement. Be cautious when you're using third-party content. Make sure, and it kind of ties into number 6, not only make sure you've got a license, but make sure you save the license. My least favorite call I have with clients is telling them, well, if you can't find the license you got from Getty Images, then we're probably going to have to pay out a settlement, because they're sending us a cease and desist letter saying that you're infringed their picture now. So save those things and make sure that anything you're using from a third party, you've cleared and that you're comfortable that you have the right to use it. And then once you do have a copyright, watch the marketplace for an infringement. Other people certainly are monitoring for infringements, and it doesn't help you a lot to have exclusive rights in something if you never go out there and see if you need to enforce them. And there are watch services that you can purchase either through vendors or that you can have a law firm set up that can monitor your work and kind of look for online infringements and kind of identify issues for you so that you can catch them before somebody else goes out and makes a lot of money on something you made. With that, with both of those, it's kind of, we thought it'd be good to kind of just side by side compare the differences between trademark and copyright, because they overlap a little bit, and I think a lot of people can sometimes get these a little mixed up. So Rhea, do you want to kick us off on this slide, and then I can wrap us up?
Yeah, so to go back to what I was kind of discussing earlier, is that a trademark is a good fit for you if you're looking to protect your brand identity and prevent marketplace confusion. So what to keep in mind with a trademark is that it's about consumer purchasing decisions. So those are things like business names, logos, slogans, product names. That's typically what you would apply for a trademark in connection with.
And a copyright, on the other hand, is your right in something original that you made and recorded. It's going to be your rights in the content your company creates, your rights in your user guides, your manuals. It's your rights and the things that you put out into the world that may use your brand, but that ultimately are expressions of ideas. And I think a good way to illustrate the difference is if you look at any logo that you produce for any of your clients, there's probably a copyright in that logo because it's probably going to be an image. It may be if it's really simple, it may not be copyrightable, but let's say it is. There's probably going to be a copyright in the image itself that will allow you to enforce against anything that looks substantially similar to that image. It doesn't matter what goods and services somebody else is using it for, you're going after it under copyright. If it's similar to your work, you can stop them. You can also have a trademark in that same logo if your client is using it as their brand. And there, it may not need to be as similar as long as consumers think that it's your client when they see that logo. So copyright will protect something that's exactly the same, even if it's used for something else. A trademark will protect something that's used for what your client is selling under that mark, even if it's not a one-to-one identical, or even if it looks kind of different, as long as consumers will be confused. And I'll let Rhea from there take us on a journey through the world of patents.
So to round out the big three of intellectual property is patents. These tend to be more technical in that they are related to inventions typically, but there are some applications to patents in the design world as well. So a patent is a right granted to an inventor for a limited time to exclude others from making, using, selling an invention, or importing that invention from another country. So there's two types of patents. The first type is the utility patent. And a utility patent protects the functionality of an invention. So that's the way an invention works. So that would be used typically for things like that have a functional purpose, like a tractor or a chair or an RV or things like that. And so, for example, to the right or to the left is a patent for a chair design. And so it's showing the functionality and the design of the chair. And then the other type of patent is a design patent. So design patents are legal protections granted to the ornamental or decorative designs of manufactured goods like jewelry, furniture, containers, packaging. So those are things that don't necessarily have a functional purpose, but more of an aesthetic purpose. So for example, the design of the Crocs shoe, which most people recognize, is protected by a design patent. So to obtain a patent registration, you file a patent application with the USPTO, so very similar to a trademark in that sense. But unlike a trademark, which rights are established by use, patent rights are established by filing date. So it is very important if you want to obtain a patent to file that patent application as soon as you can so that you can obtain that right. And it often takes 1 to 4 years to obtain a patent. Patents are often very technical, and it gives you a 20-year protection for a utility patent and a 15-year protection for a design patent. So why patent your ideas? It prevents competitors from producing similar looking or similarly operating goods as you. It deters imitations, free riders, knockoffs, dupes, and generates licensing revenue for you. Should people want to make similar products, they have to ask you permission and pay you for that right. And it gives you access to new markets, and it boosts your corporate image because it allows you to protect those designs and protect those inventions and control the way that they're used. So kind of the takeaways for patents is that knowing the two types. So utility patents protect how something works, and design patents protect how something looks. Patents are pretty technical, so consider professional help. A patent attorney ensures that an application is accurate, more likely to succeed, that you don't have to make edits or corrections to the application, and filing as efficiently and early as possible, typically within a year of disclosing the invention to the public or disclosing the design to the public is the best way to protect yourself and your brand. And the applications must go through the USPTO, and then it is formally reviewed by an examiner. And like we said before, utility patents can last for 20 years and design patents last for 15. And that's when the date of the patent is granted, not the date that you apply. And then kind of moving into a different topic, I'm sure you've all heard about AI and everything that it's involved with. It seems to be everywhere. And so as AI rapidly evolves and becomes part of our society and the business world, it also has touched its way into intellectual property. And the area where it's had the most impact is in copyright law. So the Copyright Office is developing the viewpoints on AI as AI itself develops and kind of finds its place in the world. But use of AI may, when you're drafting, writing, drawing, visually depicting, can pose complications to a copyright protection. Right now, the policy at the Copyright Office is that anything that's generated wholly by AI is not copyrightable. You are not able to list AI as an author on anything that you file with the Copyright Office. And that includes any AI platforms, so ChatGPT, Dreamscape, all those. And assisted uses of AI can be evaluated on a case-by-case basis. A lot of times they will look at how much of it was used, how much of it was revised by a human, created by a human. It's a very gray area right now. So it's important that if you're using AI in your writing, your like drafting, your drawing, your brainstorming, that you keep track of where and when you're using it, of what parts of your work have been touched by AI. And this can include anything, even things as small as editing, clarifying, grammar changes, proofreading. All of those things are considered by the Copyright Office, so it's important to keep note of those. And then it's also important to ensure that if you're using AI for anything, that it's not pulling somebody else's copyrighted works and giving it to you as a novel written piece, because that's a very easy way to infringe on somebody else's copyright accidentally. And since copyright is a strict liability offense, even if you do it on accident, you can be held liable for that. So right now with AI, it is just a very new landscape for everybody. And it's just important to be careful and to cover your bases if you are going to use it. And now Garrett's going to kind of go into some things you can do to perfect your IP strategy moving forward.
And so we titled this program the IP Basics and Pitfalls because we tend to see a lot of the same sort of situations in our line of work pop up. And hopefully we can help you avoid some of those so that you're calling us with happy news and not calling us with a report of a nasty gram you got from some other company. So the first one is not having an IP strategy. And that sounds really basic, but it is something that a lot of companies kind of really think of on the back end rather than the front end and end up stubbing their toe. When you create a new product, if you create any kind of content, if you create a new brand, it's worth thinking what are you doing to protect it? How are you turning that into an asset? How are you making sure no one else uses this? And also, that can open up obtaining registrations on copyrights, trademark, patents can open up a lot of options for a company. For instance, because those are an asset, you can usually use them as security to get a loan, depending on the fame of the trademark or the usefulness of the copyright or patent. And once you have those registrations, be clear in your internal documents on who owns them. You don't want to end up with an employee 10 years later, once you've made $1 billion using this design as your logo, an employee coming back and saying, "Hey, I've owned this the whole time." I've seen it happen, and it's not fun for anyone except maybe that employee if they've got a good case. And then train your team and make sure that it's not just the C-suite level that knows these things, but that it's the people that are actually going to be having these ideas, and the people that are actually going to be implementing them are the ones that know what to look for, the ones that know when they can protect something, when they can't, and when something's going to be an issue. Second pitfall that we see all the time is to skip IP searches. We referenced a few times that there are ways to either on your own or preferably with an attorney have trademarks or new copyrights kind of cleared beforehand to make sure they don't step on third-party rights. That is something that is always better to do on the front end than the back end. As much as I hate telling people no on a new trademark that they'd like to use, I'd rather tell people no before they've used it and before they've accumulated any liability or before they've invested in the brand. Because I can't tell you how many times we've gone and filed for something that the client decided not to search, and then they build out the brand, and then they get a rejection from the USPTO on something that we probably would have caught for them. And then they end up having the kind of a Hobson's choice between either keeping the brand and not being able to protect it, and maybe exposing themselves to liability, or going through an expensive rebranding process. 3, innovating without rights. It's when you are doing new things with your company, make sure that you're working out on the front end who owns what, and that anyone who's working on it has signed something making it clear that it's the company that owns it, and not them themselves. I mentioned earlier that work made for hire law and copyright is probably the thing I see attorneys get wrong the most. And that is something that we see a lot happening on the back end, where even actually, funnily enough, sometimes it's even marketing firms that are, saying, "Hey, actually, we do own the copyrights in this. You hired us to produce this, but it wasn't a work made for hire. You have a license to it." Those kinds of things, maybe that's a fine way to structure a transaction, but everyone should know that on the front end, and it's worth entering into clear contracts to make sure that there's no disputes, because everybody's friends until you start making money, and then people start to argue. 4 is failure to protect or enforce in the right jurisdictions. IP protection is territorial, like any other property right. Taking it back to that definition of property, it's a right that someone else will enforce for you. Well, if you leave the United States, you're less likely to be able to get the United States government to practically enforce those rights for you, unless you've registered it in the place where you're using it then. So there are strategies to seek protection in multiple or even a global number of jurisdictions at once for copyrights and trademarks. That's something that a law firm can help you with, and make sure that before you expand to new places, you've cleared these rights just like you did in the US, and you've established protection for them to stop your competitors from stepping into your space. And then the last one is not budgeting for IP. I've referenced a few times that it's, as much as it honestly sucks to pay for this stuff on the front end and to go through this process on the front end, it's always going to be more expensive on the back end if you do run into an issue. For instance, trademark damages are typically any income that the company has that can be traced back to the infringing mark. If that's your house brand, then that can touch just about any asset your company has. It's always cheaper and easier to make sure that you're ticking these boxes first, and not getting a letter that could ruin your week, your month, your year, or even beyond that. And I think with that, that gives us about 5 minutes left if anyone has any questions, comments, or concerns. Otherwise, we can give you all 5 minutes back in your day, and we'll look forward to seeing you all at other Indie Design Week events. Give it just a minute in case anybody wants to pop any in the chat.
Thank you, Garrett. Thank you, Rhea. Yeah, again, like Garrett said, if you guys have any questions, feel free to drop them in. Otherwise, yeah, thank you guys so much and have a great day, but we'll hang on for a few minutes.
All right, it looks like that will be a wrap for the chat. I will turn my camera off and hang around here until noon, just in case anybody does have questions and just isn't a fast typer. Otherwise, we've got our info up on the screen, so feel free to reach out if any questions do occur to you all. And thanks so much for your time today. It's been a pleasure presenting for you guys.
Thank you so much.